Hi there. This week's lecture is going to focus on two things I think of critical importance to all Americans: civil liberties and civil rights. By civil liberties, we mean these are privileges we all have individually as Americans. They stem mostly from the Bill of Rights and include such things as freedom of speech, freedom of religion, the right to bear arms, the right to due process. By civil rights, we're talking about the rights that mostly come from the 14th Amendment, the Due Process and Equal Protection Clause. And the 14th Amendment guarantees equal protection to all groups in society. And so if you want to think of civil rights, you can think back to the civil rights movement of the 1960s, the struggle by African Americans to gain equal rights to all other groups. Civil rights have also involved the rights of women, of gays, of the disabled, to equal protection of the laws. And one thing we're going to find with civil rights and civil liberties is that the courts have played a major role in delineating what those exactly are. And this really goes back to separation of powers. The Constitution is the basic law of the land, and it's up to the courts to interpret what the meaning of the laws are. And so when we come to civil liberties, we're going to zero in on the Second Amendment, the right to bear arms. Second Amendment's very short. Basically says you have a right to the government cannot infringe on your right to bear arms. But what exactly does that mean? Does that mean we can carry a nuclear weapon down the street? We can carry a loaded shotgun into a classroom? Well, the Constitution doesn't specify this, so it's been left up to the courts. And big court cases come up. Can the government restrict that? Is that absolute? Can I carry a weapon into a classroom loaded? Well, maybe not. So how do we determine? And there's two schools of thoughts in terms of how the courts ought to determine what the extent of our rights are. One is the idea of original intent, that judges should get in the minds of the people who wrote the Constitution and figure out what they meant. This is all known as originalism, and this is what really Justice Scalia had been a leading proponent of. When it comes to the Second Amendment, we're going to see a debate. Can Congress in any way limit the right to bear arms? And we'll find the debate starts off with two groups having their own argument over what was the original meaning of the people who wrote the Constitution. And one group will sort of say, yes, it was limited to meaning. Another group, no, it was absolute. They meant something else. And one group supports arms control and the other group didn't. What Daniel Farber comes in and says, you guys both have it wrong, that you're going about it the wrong way, that we can't get in the minds of the framers, and it wouldn't be helpful for us to try to do that anyway. The world has changed a lot, and the Constitution has to be seen as a living document and adapted to modern times. That the Constitution provides general guidelines and a spirit, but we have to make it work for us in light of our realities. When the framers wrote the Constitution, we didn't have sawed-off shotguns and nuclear weapons, nor gang violence and the kind of urban problems we have today. That's where we get most of our gun violence. We didn't have the problems made with domestic violence in the same way. So, this is a huge debate that doesn't apply just to the Second Amendment, but applies to the whole way we look at the Constitution. And it gets back to the earlier question I asked at the beginning of our study of the Constitution with Earp. And who are the true guardians of the Constitution? Those who want to constrain it, such as the Tea Party, and severely limit the powers of the government, are those who want to say, let's look at the Constitution as a set of principles that then get applied to modern times. As we turn to civil rights, same set of questions, same general set of questions. What does equal protection mean? Seems very simple. Oh yeah, we all deserve equal protection of laws, but can any law discriminate? Can we not have laws that say younger people can't drive or younger people can't drink? Well, obviously these have been allowed to stand. So when can the Constitution say one group of people gets one thing and another group gets something else? And sadly, some of this, the 14th Amendment really covers two things: equal protection and citizenship. And what does it really mean to be a citizen? What rights does that entail? And who gets to be a citizen? You'd think this is pretty cut and dry, but a number of years ago, there was this big debate over anchor babies. And I thought it was dead and gone. I was about to revise the lecture and say, yeah, no one's debating this anymore until Donald Trump brought up this fear of anchor babies. And this is this concept that people might come here, have babies, bring them back to their home countries, raise them to become terrorists, and then they would have the right to come back here and do harm to us. And some people feel that we even need to revise the 14th Amendment to redefine citizenship to prevent this kind of nefarious action. You can see a videotape on this from CNN and read an article that takes a different perspective on it. My sense is that getting here is really not the hardest problem, that whether someone's a citizen or not, they want to come here and do harm. It's pretty hard to stop someone who's very determined. But anyway, you'll get to sort of see our ongoing debates over the 14th Amendment, civil liberties and civil rights this week. Enjoy it. I hope you think about it. Take care. Bye-bye.